Great. So I'm just going to start up the PowerPoint, and please yell out if there's any issues that you're not able to see anything, or if the volume drops off. Yeah, just give it a yell. So starting off by thanking you for attending the CLE on legal avenues and supports for tenants experiencing domestic and family violence. As I said before, my name's Al Cabri. I'm the tenancy solicitor here with the Tenants Advice Service at Darnford Legal Service. So just before we get started, an acknowledgement of country. We're obviously here in Darwin, we're meeting on Larrakia land. We pay our respects to elders, past, present, and emerging, and acknowledge that sovereignty was never ceded. This is just a bit of a slide to give an overview of how this session is going to run. So going to talk a bit about Darnford Legal Service, what we do. Then we're going to move on to the substantive elements for discussion, including common issues that can arise for tenants who experience domestic and family violence, the overlap between legislative schemes, which are primarily the Residential Tenancies Act and the Domestic and Family Violence Act. They're referred to as the RTA and the DFVA. And the support services available for tenants and referral pathways for service providers, and ending on kind of the general where to go for assistance for tenants in the Northern Territory. So just to talk about DCLS, so this slide keeps popping up on the screen. I don't know if I can put that. Yeah. So we just have to manually admit people as they come into the waiting room. So Darnford Legal Service, we've got a few different branches, starting from the top to the bottom. We've got the Seniors and Disability Rights Service, otherwise known as SDRS. They're Northern Territory wide, but some of their assistance is specific to certain regions, but they generally provide advocacy and assistance for older people and people with disability. The focus areas of theirs is NDIS appeals. We've got the Veterans Legal Service, which is an outreach service for general civil legal advice for veterans by veterans. We've got the General Service, which does most civil matters, and we've got an after hours drop-in clinic that runs throughout the week and on some weekends. Our website has all the information if you're interested in attending or you're wanting to refer something in just a drop-in session. I think there's a noise coming from someone's end. If you're not muted, maybe try doing that just so that goes away. And finally, we've got the Tenants Advice Service, which is legal-wide assistance for tenants, as well, territory-wide legal service for all tenants, as well as for resident lodgers and caravan park residents. So that's just a summary of what we do. Some more information, you can see our website. So going to start off with talking about some of the common issues that tenants can experience with when DV occurs in their relationship that affects their tenancy. So generally speaking, tenants are vicariously liable for damage that occurs to the premises. So this is section 12 of the Residential Tenancies Act. You can see on the screen that sorry. Just lost the chat. So you can see section 12 of the Tenancies Act, or the beginning of it, that subsection 1 says the term of the tenancy agreement that if a person other than a co-tenant while on the premises with the tenant's consent performs an act that had been acted, the tenant would have been a breach of the agreement. The tenant takes on the liability for that person's actions because they're there with their consent. And generally speaking, all tenants to a tenancy are jointly and severally liable. So the actions of a co-tenant you can be held liable for. The exception to that is a tenant who's not responsible for damage to the property that occurred due to an act of domestic and family violence. So subsection 3 of section 12 says that if the person who performs, so the subsection 1 doesn't apply if, so the clause on vicarious liability generally doesn't apply if the person performs the act is in a domestic relationship within the meaning of the DV Act. It's an act of domestic violence, and it's reasonable in the circumstances to not take the tenant to be responsible for the purposes of this act. So, in those situations, a tenant won't be held liable. There's a bit of a grey area in how that's been interpreted. So obviously the previous section refers to other than a co-tenant. So there's a bit of a grey area where the domestic violence is being carried out by a co-tenant against another co-tenant, particularly the general principle that tenants are jointly and severally liable. If that is kind of an issue, we'd probably recommend people seek specific legal advice on that, because there's a few arguments that you can raise. The tribunal is generally, I think, in favour of interpreting this subsection broadly to say that if it's between co-tenants, a tenant is still protected, and that they're still not to be held liable even if the actions are by a co-tenant. The alternative argument, if the tribunal isn't wanting to read it that way, is to ask that the liability between the co-tenants be severed, and that the tenant not be responsible. So there's either an explicit argument along the lines of section 12, or it's one that basically runs alongside of section 12 using the same logic. There's not been a ruling by the NTCAT, by the tribunal, and so it's still a bit up in the air. And our kind of guidance from the tribunal thus far is that they're not going out on a limb to make any of these decisions, because it is a tricky area for them to kind of decipher as well. We do experience, just on a more practical level and less of a legal level, but when we're talking to real estate agents, the understanding of this provision, understanding of the liability not attaching in the DV situation, it varies pretty drastically. Some real estate agents or landlords are pretty open to, very sympathetic to damage caused, and they say no worries, get it covered under insurance or whatever the case may be. Others are very unsympathetic and say, yeah, well, you caused the damage, or the damage was caused in your tenancy, so you're liable for it. So if that's an issue that someone's experiencing, or a client of yours is experiencing, we suggest that you refer them to us for legal advice, because sometimes the difference in that sort of situation can just be a lawyer sending an email to a real estate agent, basically quoting what I've just quoted to you, so that they can kind of take it a bit more seriously and hopefully drop the issue entirely. But that's the vicarious liability provisions. In summary, there's a protection for tenants who are experiencing DV. Can be a bit of a grey area, but if in those situations, generally seek legal advice, just so that all your grounds are covered. Next is looking at the options for an early termination of the tenancy under the Residential Tenancies Act in particular. So this is a case where it could be a case where someone's experiencing DV and they're wanting to get out of their tenancy because they've broken up with their partner or whatever the case may be. Generally speaking, there's 4 ways of ending your tenancy early. We generally advise as a starting point to ask for a mutual termination, just because that is the one that is most cost effective and that it's free, and both parties can walk away from it with no liability to that contract. So a mutual termination is both parties agreeing to walk away, and you can compare that with abandonment or breaking the lease, where a tenant is seen to have broken their or breached the contract, and therefore liability can be attached to them. So as a starting point, we recommend that people ask for mutual termination. We have found that real estate agents can be sympathetic in these situations. Like everything, it's a bit of a mixed bag though, so you can't rely on that. But generally, yeah, they can be sympathetic. And if there's allegations or the potential for property damage, they might also kind of go in favour of terminating the tenancy. The only issue with the mutual termination is where there's co-tenants, because both of them would have to agree to be letting the tenancy end. The second option is an assignment. It's a tenant's right to assign their tenancy, and a landlord or real estate agent can't unreasonably refuse that. The issue there is just it might be a bit sensitive to be assigning a tenancy depending on the situation, and it requires a bit of a legwork on the person who's wanting to assign their tenancy, because they've got to find a suitable applicant to put to the real estate agent or landlord. The next one we have is abandonment or breaking the lease. As I mentioned earlier, it's seen as a breach of the contract, so liability can attach to a tenant. However, there are some rules and procedures that the real estate agents need to follow, which they typically don't. So they'll typically just kind of demand that you need to pay rent up until the end of your tenancy, or a new tenant being found. And you need to pay administrative fees and advertising costs, that sort of stuff. Just so it's clear for everyone, when you abandon a tenancy, it's seen as abandoning it for good. As soon as you hand back the keys, you're under no further obligation to continue paying rent, and you're under no obligation to pay any amounts until that claim is brought upon by the real estate agent or landlord to NTCAT and is substantiated there. So they've got to go through NTCAT and they've got to bring their claim for compensation within 3 months. Up until that point, they can demand all they want, that you pay break lease fees, that you keep paying rent, that you're, weeks in arrears, but they need to actually go through NTCAT to substantiate that. The last one there is a hardship application, which is a Section 99 application, which we're going to talk about next, and it's probably the most relevant one, but probably the more difficult one to establish, just because a lot of the time, it requires automatically going to NTCAT, and then it can just be a bit of a process. And so if someone's come to you and they've exhausted all the other options, and they're mindful of breaking the lease and whatever that might mean for them, we'd recommend seeking advice to see if they can get a hardship application instead. So onto hardship. So the hardship application is basically an application that can be brought upon by either party, a tenant or a landlord, that is seeking to end the tenancy early on the basis that the continuation would result in undue hardship, and the circumstances of that hardship hadn't existed before entering into the agreement. And the tribunal, when they make that order, they will specify the date that the order is to have effect, and they can be a bit flexible in whatever date they set forward, for reasons that I'll explain. So generally speaking, NTCAT is hesitant to interfere with the contractual relationship between a landlord and a tenant, and will balance the interests of both in coming to a decision as to whether to grant an undue hardship application. And on the slide, you can see a quote from a case of NTCAT called A, B, and CD and XYZ Proprietary Limited. It was quite a sensitive case, so NTCAT obviously made all the parties anonymised when they published their decision, but the relevance of this decision is that it's basically restating the principle of statutory interpretation, that legislation is not to interfere with vested proprietary rights. So a construction that favours maintaining the contractual intentions of the party is to be favoured. Then the second quote there is kind of speaks to what NTCAT are looking to in when they're looking at hardship applications. So just bring out some keywords there. Even if the circumstances of hardship are established, there remains the need for a careful weighing of the respective interests of the parties suffering hardship and the party who necessarily will be disadvantaged by the termination. It's only after those interests have been weighed there can be a proper decision as to whether the hardship is undue. So reading all that together, it's just quite a high bar. And this next slide kind of there's a bit of history to how the hardship has been interpreted. In recent years, NTCAT has narrowed the scope. And so there's a quote again from AB and CD saying that it may be the approach previously taken in this jurisdiction as to what constitutes grounds for termination under Section 99 requires reconsideration, particularly in circumstances where inability to pay rent is central to the application. So this was off the back of a few decisions that looked at a tenant's inability to meet their financial obligations due to job loss, for example, as being enough to establish undue hardship. So it's kind of a move away from that. A loss of employment basically doesn't mean a loss of the contract of the tenancy. So this next slide is just a few examples of what constitutes is seen to constitute hardship. So in the first case, it was an example of a person who had significant knee swelling and they required surgery. They lived, I think, on the third floor. They wanted to end their tenancy. They applied for hardship. The landlord argued for a lease break, and NTCAT ultimately found that it was undue hardship, and they ordered the termination of their tenancy because they weren't able to actually access the property without significant effort. The second one is the AB and CD. It's where assault on. There was an assault on a tenant by a visitor to the property. Subsequently, a DVO was put in place. So the person who committed the assault was known to the tenant, and they is pretty heinous assault was carried out against them, and they suffered significant harm. The co-tenant, who was the first person to see the tenant who was attacked after the fact, was significantly shaken up as well. The tribunal found that that was enough to establish undue hardship in the fact that neither tenants could reside at the property anymore. The next case is in the situation where the co-tenants, there was DV happening at the property. There was a DVO subsequently put in place between the co-tenants. The applicant in this case couldn't reside at the premises. There was a no contact DVO, and she brought about a Section 99 application. The second respondent was the ex-partner and also the co-tenant. He opposed it, and the first respondent, being the landlord, argued that the hardship to the landlord themselves and to the ex-partner, as a perpetrator, if the tenancy was terminated, outweighed the hardship to the applicant. The applicant sought to argue that she could potentially be liable for any missed payments by her ex-partner, but the ex-partner made commitments that he was able to meet the rental obligations. The matter continued for a little while before, and it was adjourned a few times before the second respondent ultimately said that he wanted to move out, and he was falling further behind in arrears. So in that case, NTCAT held that undue hardship had been established, but only because basically the rent wasn't going to be able to be paid. At the bottom of the slide, there's just some more examples of unreported decisions. The first one is the case of a dispute between co-tenants. The applicant felt unsafe around basically her housemate, but there was no police involvement or DVO in place. The landlord didn't oppose the application, so didn't oppose the tenancy coming to an end. but NTCAT looked at the hardship faced by the remaining tenants, so people who wanted to continue on in the tenancy, and found that to outweigh the applicant's financial hardship in the fact that she was continuing to pay rent at a property that she couldn't reside at. Interesting in this case is that it basically shows the tribunal's rationale in balancing up all of the interests of the parties to the contract, so where the co-tenants' interests diverge. And it also made a specific reference to the existence of domestic violence provisions that speak to alterations to a tenancy agreement, which potentially carry the implication that NTCAT is saying that's the appropriate jurisdiction to go about changing a tenancy agreement. But there wasn't anything really specific on that point, and there's not been anything further that NTCAT have kind of shed a light on how they would approach these types of situations. The next example is DVO was in place between co-tenants, and the main argument was the tenant was not able to meet her rental obligations in paying money. At the time, it was the COVID modifications were in place, which had widened the scope of undue hardship to specifically include financial hardship. And in that case, it was able to be established that undue hardship was present and the tenancy was terminated. But that was pretty specifically just because of those modifications, which are no longer in effect. And the last example is one that is pretty unproblematic in the sense that if there is kind of a terminal illness or the urgent need to move to care for someone or to care for yourself, if you've got a medical condition that can't be treated wherever you're residing, that generally would meet the criteria for an undue hardship application. I'm just keep going. We can send them, whoever's locked out, we'll send you it later. So yeah, hopefully those examples kind of just give a bit of a sense of what is and isn't undue hardship. It's interesting that even in cases of DV, the tribunal is still looking at the interests of the landlord and the co-tenant. Whereas I'll speak to it a bit later in DV, it's not so much for consideration. So, and then this is just an example of early termination brought upon by a landlord or sought to be brought upon by the landlord. So I believe that Najaran with the CEO Housing in Russell, they sought a termination under Section 99A for breach of the antisocial behaviour agreement and Section 100, Section 1 for unacceptable conduct by a tenant. NTCAT ultimately found that the evidence provided by housing was lacking and they couldn't establish either of those grounds. And so even though the respondents had brought on issues to do with vicarious liability and the Section 12, subsection 3 argument to DV, and was kind of trying to make that argument, it ultimately wasn't decided because of the lack of evidence. So I guess that's another thing to consider that often arises in public housing applications is the prevalence of domestic violence that could be occurring, and if that needs to be factored into any arguments at the tribunal. It's a bit of a difficult area just because if one breach of an ABA is established, then that kind of sets the tone for making out that claim. But we do try wherever we can to put in the fact that DV is occurring, or if it is occurring, that to argue that fact and to say that can potentially undermine some of those complaints that are coming through from neighbouring residents. ultimately, in that case, the NTCAT awarded costs against housing due to housing's breach of the model litigant policy and their own domestic and family violence policy. So it's a bit of a good news story and a bad news situation in the fact that they kind of got held to account at the standards that they were not upholding. That's a bit of an aside from undue hardship. And now we're going to be looking at the overlap between the legislative schemes of the Residential Tenancies Act and the Domestic Violence Act. So in summary, both acts give the power to order that a tenancy agreement be terminated. However, NTCAT, or the Residential Tenancies Act, only allows NTCAT to order or cannot order a new tenancy agreement be entered into. So it's termination and that's it. Whereas the Domestic and Family Violence Act also allows entering into a new tenancy agreement with different parties to it. Both acts consider the effect of the termination of the parties to the agreement, primarily the tenant and the landlord. However, they come from very different vantage points in respect of the considerations given to the interests of the tenants, of the co-tenants. So whereas NTCAT considers the effect of the termination on all the co-tenants, whether they are in support of the hardship application or not, the local court really is just looking at whether the protected person consents to the termination and is looking at whether the defendant, if they're the ones who are to remain on the tenancy agreement, are able to comply with it. So that's basically if they're able to continue paying rent. I think that is up there. So I'm going to go and look into what the Domestic and Family Violence Act actually says about these replacement tenancy agreements. This isn't an area that DCLS practices in, so I'm sure there are a lot more experienced people. One of them is in the room with us in the VV space, but just as a general overview of what Section 23 sets out, is basically that a tenancy can be terminated and a new one be entered into that changes the parties to the agreement in summary. And it applies if the defendant and protected person live together or have previously done so, and they're both tenants to the premises, and either a court DVO has a premises access order in it or the protected person no longer wishes to live at the premises. So the orders that the court can make under Section 23 is an order terminating the agreement and the creation of a replacement agreement, either for the benefit of the protected person and anyone else who is a party to the terminated agreement other than the defendant, or with the agreement of the protected person, they can order a replacement agreement for the benefit of the defendant and anyone else who is a party to the terminated agreement. So basically the general rule is that it has to be for their benefit, the protected person, unless they agree to the change of being to the benefit of the other person, the defendant. Yeah, this is a restatement of what I said before, that the replacement agreement is identical to the original agreement except for the parties to it. So the preconditions to the court ordering that Section 23 is that they must be satisfied that there's a domestic relationship that's broken down permanently. There's no reasonable likelihood of them living in the premises free of domestic violence. They'll be able to comply, whoever it is who's remaining on the tenancy agreement will be able to comply with it, and it's appropriate to make the order in the circumstances. They'll also look at whether the landlord consents to the orders, or if the landlord refuses, whether that's an unreasonable refusal. As well as whether the person themselves or the protected person themselves consents to the order being made. Subsection 4 says that the landlord and anyone else having interest in the premises are entitled to appear and be heard in relation to the matter. As a generally good thing to do is if you're in a situation whether you're self-represented or as a practitioner, is if you're seeking one of these orders, is to give advance notice to the landlord that this is coming their way. They have to receive notice prior to this being asked for at least 2 days before it gets to court. but even there's a formal notice to follow, and it's available on the local court's website. But prior to that, just letting them know in advance that this is coming so that you can get a sense that they would be on board. Generally speaking, or like anecdotally, landlords generally agree. It'd be pretty difficult to refuse, I'd suggest, but yeah, there's not been many instances of the landlord saying, no, I refuse to consent to this order. And I would hazard a guess that would really only be seen as reasonable in situations where there's real doubts as to whether the person remaining on the tenancy agreement can meet their rental obligations. Subsections 5 and 6 just look at the fact that the agreement has to have the same conditions as the original, and that it is ending at the same date. I think that's all. Yeah, in summary, the main consideration is really in regards to rental payments, which is similar to NTCAT's considerations as well, minus the fact that NTCAT is looking at the tenants combined. And kind of coming to the end, so for support services that are available, I'm sure most people are aware of the Women's Legal Services and Domestic Violence Legal Service. They're generally who we would turn to if this was a DV issue was on the cards, and there's of course many other domestic violence services offering emergency accommodation, things like that. Just for the purpose of this, I've limited to the legal services operating in this area. And generally speaking, for referral pathways, kind of broken it up to say that if there's apparent grounds for a DVO is currently being sought, or there's an interim one in place, and for family violence is a substantive or immediate issue, refer to a women's legal service or the DVLS. If the client isn't seeking a DVO, isn't interested in that, or there's multiple tenancy issues, or that is the main issue, the tenancy, refer them to TAS, the Tenants Advice Service here.
What's TAS?
TAS, Tenants Advice Service. Yeah. So refer them on to us, and if we can sort it out from there. If we're thinking that okay, there's this issue, but it probably needs to be more specific advice on the DV scenario, then we'll handle that from there. But as a general rule, that's a way of breaking it up that we've kind of arrived at. And happy to take people's thoughts on that as well. And I think the last slide is just on resources and help for tenants. So if you're experiencing tenancy issues yourself, or if you know of someone who is, a good point to send them to is our website. It's got lots and lots of information. And a lot of what we speak to on a daily basis sits there as well. So it can be a good place to go to just in advance of an appointment. Might help to answer some of your questions already. And generally, if you're in doubt, just refer them on to us, and we can book in appointments. Sometimes issues are a bit more complicated than they appear. But I guess as a general note, for tenants experiencing DV, I think in a lot of instances, people aren't aware of the protections that do exist. And I mean, in reality, they're a bit confusing to work with, and it's a bit of a grey area, and NTCAT have really been forthcoming in how they've interpreted the provisions that do exist, but they are there, and our service exists to help people who are in that situation to kind of try and make it a better scenario for them through what is available. And hopefully, as we go on, we'll be able to get more and more definitive decisions from NTCAT about how these provisions are interpreted, which can kind of solidify things that we can then argue to the real estate agents and landlords, hey, this is the way it is, and this is how you should be acting in this situation. So I think that's it in terms of the content, but if there's any questions, I'm happy to take those. Yeah, just yell out if you've got anything to ask.
I have a question.
Yeah.
Hi.
My question is, so you mentioned in the DVFA, so the Domestic and Family Violence Act, Section 23, the tenancy can be terminated and a new one entered into.
Yeah.
It's only for the defendant who wants to stay there. There's no new tenancy agreement entered into where the person who's experiencing the violence is able to stay and then the other person is to move out.
If you go both ways.
Right.
So if it's going to be for the defendant, then the protected person has to consent to them making a tenancy agreement to the exclusion of the protected person, the defendant. But it can also go the other way where it is excluding the defendant. So it operates both ways. It's just really, I think, left open to allow for whatever circumstances that the person isn't able to meet the rental obligations themselves and response to get out of the tenancy because they're concerned about the potential liability that they're going to be taking on if their ex-partner, whoever it is, stops making rental payments. It's just a bit of a proactive way to cut that off before it gets any worse.
Right.
But yeah, generally speaking, it goes both ways.
You got a question?
Thank you, Michelle. Appreciate that. Thank you, Michelle and John. Yeah, if there's no further questions, so if you're struggling to ask one technical reasons, you can obviously just shoot us a line at the Tenants Advice Service generic inbox. It's tas@dcls.org.au for Tenants Advice Service. And yes, we will be sending out the slides. Thank you, Mission Australia. And yeah, if there's anything that we didn't quite cover, you're welcome to give us a call and have a chat about it. But otherwise, I think probably brings it to a close.
Yeah, thanks very much. That was great.
Yeah, thank you. Thank you for coming.